merchant could, someone who remitted all their receivables and it was a clean transaction and it was done, but the merchant, for whatever reason, wants justice, has just found out from their attorney that there's a potential claim, and they want to get a windfall against their MCA funder, so they could go back 4 years and start bringing up old claims. And if a class action were to be certified, and one merchant could represent all the merchants of a funder, they could bring up all the claims over a 4-year period.
Wow. That would
So
be
it's significant, and it's probably one of the biggest challenges that MCA funders are facing today in the legal world.
So today's video, we're going to cover a number of legal topics with our guest today. He's actually the author of an article he just published called STNY is the New Worst Place to Litigate MCA Disputes. So really looking forward to this conversation. We're going to get into a number of the different cases that are ongoing that he's covered or he's reading about, things that businesses, funders, brokers can do to protect themselves, and some of the other things that are evolving in the industry. So my guest today is Jacob Nemon. Jacob, thanks for coming on.
Thanks, Shane. Thanks for having me. I'm excited to talk about these topics.
Certainly. There's so much to get to. We're going to cover as much as we can. Loved your article, and there's a couple cases in there that I wasn't familiar with, including the Principus one, the Fleetwood one. So we're going to get all into those and much more. First, just catch me up on a little bit, and everyone on your background and how you got into this legal space.
So I've been around thanks again for having me. I've been around the merchant cash advance space for, about 11 or 12 years, which is about the length of my post-law school legal career. I had started out working for a small firm that was doing a lot of business with one of the grandfathers of this industry. We were doing a lot of litigation. Some of it was related to business disputes, but it touched on the merchant cash advance stuff. And then when I came to my current firm in 2015, when merchant cash advance litigation in New York was really kicking off, I was really well positioned because I knew a lot of the players and the names and a lot about the business, that I just started tracking that litigation through the New York court systems. I would, be involved in some of those cases. I followed the attorneys that were doing a really good job at setting precedent that really has enabled the industry to become as well-grounded legally as it has today, and even contributed to a few wins myself.
Great. Okay. And so this article, we'll get, kind of right into it. It caught my eye, and we hadn't talked before or anything else. And so I found it, and I think it was kind of republished in a couple different spots. And so you get into a number of different things. What are your, kind of most important topics, I guess, from that? And there's the RICO one, there's a number to choose from. Kind of prioritize those for us.
So I'll take us a step back a couple years ago. Having been following the legal developments in this industry for a while, and seeing that there had been case law developed that really established what the law was with respect to merchant cash advances, and that there'd finally been some New York appellate courts deciding on those cases. And I focus on New York because I'm from New York. I live and work in New York, but also because much of the merchant cash advance legal analysis comes from New York courts, because many of the companies started here. But I realized that after many years of litigation and many cases, dozens of cases, some of the appellate courts in New York had begun taking up merchant cash advance cases and had decided on a test that would control whether a merchant cash advance was a true purchase of receivables and therefore not subject to our usury laws.
Hmm.
or whether it was in fact a loan and therefore an illegal agreement that would be vacated. And I thought it would be important to sort of write about that and really put that in one place where people could reference. Um,
Sure.
when I started thinking more about it, I realized that, while New York courts had developed a good way of looking at merchant cash advance agreements and deciding which ones are valid and which aren't, these disputes don't only come up in New York, they come up all over the country, um, often because merchants will bring their own litigations in their home states. Merchants, of course, are not all located in one state, they're throughout the 50 states. And there were cases that were going through the bankruptcy courts, and there were decisions that had come down very unfavorably, perhaps because it was bankruptcy court or because it was out of state, and the judges were more favorable towards the debtors that lived in that states than some foreign finance company out of New York.
Right.
Um, but I had dubbed out of state being the worst place to litigate a merchant cash advance dispute.
Okay.
Um, and in the past year, as many people may know, but people that haven't been tracking the legal updates in the MCA space may not be aware. Um, New York federal courts have actually become a very challenging place for merchant cash advance litigation. That started with a case called Fleetwood Financial back in June 2016, which was a lower federal court decision. So it's not binding on New York state courts, but it's coming from a respected federal jurist, so it matters. Um, and it set a precedent that was not particularly helpful to the MCA industry, um, but that was followed by other federal judges, including influential judges, that began looking at merchant cash advance transactions a little bit differently than the New York state courts had done. And they did it in the framework of a RICO litigation, which is a civil claim, but it's a civil racketeering claim. And it could impose lots of liabilities on funders or people in quote unquote conspiracy with the funders, for trying to collect on an unlawful debt, which could be a usurious loan. So it really did create a little bit of unknown. The Fleetwood case in particular, because it was revolutionary in its analysis and how it deviated from the standard way that New York courts were looking at MCA agreements. The civil side of that thing is the statute said that in addition to whatever state law claims you have, and usury is really an element of state law,
Hmm.
in addition to whatever state law claims you have, we're going to enhance the civil claims that you would have for taking usurious interest on a loan, in that we're going to impose attorney's fees for the borrower. We're going to impose actual damages, which is the amount of usurious interest they had paid above the principal. And just to punish you, we're going to charge treble interest on the damages, which means we're going to triple those damages. And this was really to disincentivize people from trying to collect on unlawful debts like a usurious loan. So it's substantial. And when you putting it into the merchant cash advance context, if a merchant cash advance agreement were to be found to be a usurious loan and to violate the civil RICO provisions, the cash advance funder and the folks that the court may find acted in conspiracy with the funder would be out the attorney's fees for the merchant, which could be very significant in a hard-fought litigation. They'd have to pay that RTR, the amount above the principal advance, as damages, and then on a really significant advance, that could be a lot of money, maybe millions, and then that would be tripled. And if this really got bad for the funder, if the funder was really doing this as a pattern or doing this to multiple merchants, and a merchant was able to get a class action, meaning many merchants could bring their RICO claims, we're talking about an amount of money that I can't even estimate for all the deals that that funders have been involved in. And one really important aspect of this that people aren't thinking about is that RICO has a 4-year statute of limitations.
Okay.
Which is longer than the New York State statute of limitations on a general usury claim of 1 year. So a merchant could, someone who remitted all their receivables and it was a clean transaction and it was done, but the merchant, for whatever reason, wants justice, has just found out from their attorney that there's a potential claim, and they want to get a windfall against their MCA funder, so they could go back 4 years and start bringing up old claims. And if a class action were to be certified, and one merchant could represent all the merchants of a funder, they could bring up all the claims over a 4-year period.
Wow. That would
So
be
it's significant, and it's probably one of the biggest challenges that MCA funders are facing today in the legal world.
Okay. And so what are the next cases, I guess, or where is that progressing with that in mind? And really anything else that you kind of tackled in the article?
So my article was looking at the progress of these cases, of some of the major cases that have come down. And there's been a few published decisions over the past year, but there's also decisions that are cases that are winding their way through the system. And there's attorneys that are filing these cases every week. There's a lot of them, and MCA funders know that they're coming. It's not a matter of if, but when. But what I've done in my article was look at how these have progressed over the past year. What's developed, because that initial Fleetwood decision was confusing, to say the least. It looked at the MCA transaction very differently than any other New York courts had done before. And they said that in addition to the traditional accepted 3-factor test of whether there's a reconciliation provision, whether there's a potentially indefinite term of remitting receivables, and whether there's any recourse in bankruptcy against the merchant, the Fleetwood decision said, let's look at a whole bunch of other factors that might say this isn't a true purchase of receivables, but this is really just a contract that keeps all the risk with the merchant and doesn't put any risk on the funder. So other cases have come down since then and have basically refused to dismiss other RICO claims that were filed. But in doing that, there's been a body of case law, a body of decisional law that's developed that's sort of given us a little more insight into how the judges, even the ones that might be viewed as not being industry friendly, are going to start looking at these cases. And there's going to be many more to come. So one of the important cases, in my opinion, was a most recent case, or a most recent decision in a case called Haymount. That was back in January, where the judge refused to certify a class action against some funders, and dropped a footnote in that case. And this is a judge who had previously denied the funder's motion to dismiss, saying that it seems that the merchant has stated enough facts to establish a legal claim under the RICO statute. But this judge dropped in this footnote that it's very possible that this agreement is in fact not a usurious loan. He acknowledged that there is a way that an agreement can be written, particularly the reconciliation clause of the agreement, that can be written that makes the transaction function as a true purchase of receivables. And I think that's incredible, because it acknowledges that that we're operating in a valid space, in a lawful space, that it acknowledges that these agreements can be written in a way, and the transactions can function in a way that it's a true purchase of receivables, even according to the strictest analysis. And what's really critical there is the reconciliation clause that if a merchant's overpaying, or if a merchant's daily or weekly remittance is above and beyond what their average receivables is, that the merchant has the ability to actually contact the funder and get that fixed up, get a true up of that, so that they're actually paying what their receivables are, rather than an overpayment. And if you can do that, and this is an agreement that's going to collect against receivables rather than a fixed amount forever, or fixed amount until you get paid back, this may very well withstand the scrutiny of the courts. So it gives us hope that we're gonna do well in future litigations as well.
And so with that, do you see, you may or may not know this, changes for the way funders are collecting, essentially, whether developing new technology or just a different process for making a true up more less with less friction, so a customer, a client, a merchant can request that, and it's less of a hassle, essentially, so that they can get it done, even though funders may not want to do it as frequently as a merchant might. But because I think that's part of the issue, right? Is one, merchants don't always know that they have that opportunity, and if they do, it takes a long time, or they can't get through, or the funder takes too long, or whatever it is, before they actually default or miss payments.
So I've heard talk recently from different funders about solutions for those issues. I mean, there are some funders that are talking about automated reconciliations, and that's I'm not an expert in technology. It may not be as theoretical as it sounds. Funders may have the ability to actually go in and check the daily payment amounts, or the daily receivable collections. But that's not mandatory. None of the courts have said you need to auto reconcile.
Okay.
But the question is, what can and should a funder do, particularly in light of a more hostile legal field? And I think that what they need to do is they need to make sure that their reconciliation clause is clear, it's mandatory, and that they actually have a system for putting those reconciliations into place. They need to be clear on what type of documentation a merchant's going to have to provide. Is that the bank statements, the month-to-date bank statements, if there's any sort of receivable reports that the merchants are generating. And they need to have folks in the office that are going to turn this around in real time. It may not have to be in an hour, but within a day or two, or there shouldn't be a lag time. Because if a merchant's receivables go to zero, which doesn't usually happen, but if there's a huge drop in the receivables, the funder is going to need to make adjustments quick, and the funder is going to want to do that. They should want to do that. They shouldn't want to put people into default. They shouldn't want to get insufficient funds. They should want to be able to work with their merchants to get paid, to get get their investment back. And I think the funders that I've worked with, most of them will tell me merchants don't ask for reconciliations, right? They're either delivering what they contracted for initially until they finish off the payment, or they hire a lawyer who just goes straight to court instead of calling up and saying, here's what the revenue looks like, and can we reduce these dailies or these monthlies or weeklies? Merchants perhaps they need to be educated a little bit better about what rights they have, but the funders are doing what they can. They're just not actually being asked to reconcile.
Right. And yeah, it's probably kind of what you're saying, to be educated a little bit more. I think there's a fine line there, probably from the funder's perspective, of putting that too much in their mind as an option to where they might take advantage of it. And so there's a balance there that they're probably thinking. But great points. And I think that's what stood out to me, just reading over the different cases over the years, as far as having the true ups or reconciliations being kind of that difference in really being categorized as a loan and an MCA or not. And And then you mentioned some other of the three, I think the three major tenets, right? What were the other two? It was the time, the length.
The unlimited duration,
Yep.
and that bankruptcy is not an event of default.
Okay. And
Uh,
so also you mentioned about fixing your contracts. Talk to us a little bit about that and kind of some general guidance.
so I'm a huge proponent of fixing your contracts, and I said that in the article, and I've said that in previous articles. I genuinely believe that in order to operate in this space, you need a good attorney who's going to be fixing contracts regularly. You need someone who's not just a corporate attorney, but someone that understands the MCA space. And unfortunately, there's not enough of us out there, but there are some really great attorneys. And the reason why I say fix it and fix it often and fix it with someone who knows the space is because of cases like Fleetwood, because of cases like Haymount, because of this ongoing evolution of what merchant cash advance law looks like. We don't have a statute or a legislature that's told us what a merchant cash advance has to include. We have a body of case law consisting of perhaps hundreds of decisions over the last 10 years that sort of point us in the right direction and give us an analytical framework to look at these agreements. But you got to keep updating them. I mean, because you also have, what my pet peeve is when I see these really old legacy contracts that some funders are using, not necessarily the most sophisticated funders, but folks that have just jumped in the industry and they're using these old contracts that they borrowed from somewhere and they slap their own name on there, and forget about the typos that are going to be in there. They're just not legal as written. I've seen them without reconciliation clauses. I was mind blown that within the past couple of years, someone was still operating without a reconciliation clause. So I'm a big proponent of fixing your contracts and fixing them regularly. I know there's attorneys out there that sort of have a subscription service where they'll put out new contracts every couple of months. But if you're not looking at these things and revisiting these things and talking to a qualified merchant cash advance attorney about what's wrong with your contract, you're probably going to end up in a situation where you have one of these usury or RICO cases down the road, and they may not only be in New York. These might show up in Florida, where a lot of cash advance companies are moving to, or in other states. There's usury laws for business loans in, I think, 18 plus states in this country. So
Right.
you could end up in a lot of trouble if you're not looking at this thing and doing it regularly. And the courts, I think, I'm not a Florida attorney, but I hear all this talk about, let's just move to Florida. That's a great state. It's a red state. It's a business friendly state. But the reality is Florida's got a strict usury law. And in the absence of binding authority, they're going to look to New York and see how
Right.
New York courts have looked at this stuff. So
Oh,
I
that's an
just
interesting
think
point.
you got to look at the contracts and make sure you're as compliant as you can be, so that when this stuff comes up, your litigator is going to be ready to face it with the best possible contract it can be written on.
And you also talked about kind of doing proper underwriting. Is that something that, I mean, there's certain things that are coming up in the cases where they've mentioned things to do?
Absolutely. They're not necessarily mentioning things to do, but they're mentioning what not to do.
Okay.
And the merchants' attorneys have come up with a very clever way to advance their cases, where they'll say, my client has taken out 10 advances from 10 different funders over a period of a year. And they'll line it up right next to each other. They'll say in January, they took out an advance and the funder estimated that 10% of the receivables was $10,000. In February, 10% of the receivables was $20,000. In March, 10% of the receivables was $80,000. And they'll say, Judge, how can it be that 10 different funders over this short period of time all estimated 10% of the receivables to be a vastly different number? And the fact is that's because of bad underwriting. or no underwriting, or that's because a funder, and I'm not saying who's right or wrong, but I'm just saying what I can tell from this is that the funders wanted to get a certain receivables, a certain amount of the recovery, and nobody thought, what is 10% of the average receivables? And what that creates is what us lawyers call an issue of fact. That's something that's got to go through discovery. That's
Mm-hmm.
something that's got to go through depositions. That's got your underwriter's probably going to end up getting deposed if that goes
Oh, so
forward.
the whole operation is going to go into court essentially.
It's gonna the whole thing, and it's not just you, it's everybody. Meaning,
Mm-hmm.
you could have been the good guy. You could have been the honest underwriter or the honest funder, and you did everything by the book. But because somebody else screwed that up, and some judge or didn't do the work, and some judge looks at it and says, well, you're not really doing a purchase of receivables at 10%. You're just taking money on a fixed basis until you get paid back. We're just not gonna dismiss this case against any of you. You're all gonna have to litigate, and that's gonna get quite expensive. And there's a lot of exposure in that.
All right. And talk about, I mean, you also kind of mentioned something about syndication and the agreements and that. I mean, those are evolving. I'm assuming then additionally they need to get them updated.
Yeah, syndication agreements are not my area of expertise, but what I can tell you is there's been a lot of activity from the Securities and Exchange Commission, from
Mm,
the Department of Justice. They're looking at syndication agreements. I mean, the cases have involved mostly where people are fundraising from the street. They're
mm-hmm.
trying to get money from smaller investors as opposed to more sophisticated investors. And they've made promises that they couldn't deliver on, or didn't divulge the risks. A syndication agreement is complicated. It's not just saying we're going to take your money and we're going to give it back. There's a lot more that goes into that, and it could run afoul of a lot of laws. So I see this all the time where people are just kind of recycling the same agreements and agreements that have not been updated in years, and they're using it for less sophisticated investors. And I think there's even websites out there now where you can, just put in your info, and and you're not that, a lot of sophistication under the securities laws. I understand it comes down to how much money you have sitting in your bank account. If you're a multimillionaire and you're sitting on a big pot of money, we're less concerned about protecting you than the small guy trying to, invest his $50,000 life savings.
Right.
But you got to protect yourself as the funder. And again, not my area of expertise, but definitely something people have to be thinking about when they're raising money.
All right. That's there's I've been seeing so many of them. There's different platforms now that you can syndicate more easily on deals that you did not even originate. So that's definitely good information right there. What about some of these other states? What can you tell us about anything in regards to other states that either have bills in the works? I mean, Florida obviously is one of those, I believe, that was just announced, I think, a week or two ago. So anything else that we should know or that you can tune us into?
I know there's multiple states that are considering it. There's only 4 states, I think, that their bills are in effect. The major, a lot of that is compliance and disclosure in states like Virginia and Utah, where you really just have to put information out there on a form, and it has to be delivered. But I mean, when you get into California and soon New York, there's a lot. It's
Yeah.
complicated. You need to put an APR, uh, which frankly doesn't make any sense, because this is a product that doesn't accrue interest over time. The amount a merchant owes to their funder will never increase.
Well,
It just can't.
I believe they're challenging that still, right? In California, they're challenging it like on a First Amendment type of thing where, yeah, I mean, how are you going to make the funder change an agreement when it's not even the correct product or information, I guess, something to that extent. But Okay.
Yeah, there's an ongoing litigation, and I believe it's, there's some motions to dismiss pending over there in California where they're challenging the California Finance Department on their rules, which essentially tell you to make a false statement, to say that there's an interest rate on a product that doesn't accrue interest.
Right.
And by the way, if you and nobody knows how to calculate it, but the best efforts we have at calculating these interest rates, they run up hundreds of percentage points.
Hmm.
And if you want something to help consumers or merchants understand the product that they're getting, telling them that there's an 850% APR on a product that's never going to accrue that much interest, that's not how it works.
Right.
I don't know where that litigation is going to go. It does seem extremely uh, bad legislation, or a bad way to help customers in my perspective. So kudos to the folks bringing that litigation.
Right. I know for sure it'll be interesting to see where that turns out. And just a couple more things before we let you get out of here. What are some of the things that funders and brokers can do to protect their business? I mean, we've touched on obviously things are evolving, so it's not, standing still, but what are some of the things that you could, give advice on?
So one thing that I believe is critical is educate your people. I mean, they need to understand this product. They need to understand that a merchant cash advance is not a loan. They need to be, when they're talking to customers, not using the L word. They need to be explaining the product in a way that's understandable, because they're in the marketing business, and the sales business, and they're trying to get funds to people that need it, but not use, not misunderstand it. And there's definitely a push to sell, but that push to sell needs to be transparent. It needs to be candid in what the product is, and the rights that merchants have. And I think just that alone avoids a lot of the problems. Um, if you're doing honest business and presenting your product honestly, you're not going to get sued for fraud. And if you get sued for fraud, there's no fraud that you've committed. You're going to avoid the problems that attorneys general and the Federal Trade Commission are bringing up against against funders. Um, I mean, look after not just your own people, but also the ISOs that you work with. Work with honest ISOs. There's plenty of them out there. Make sure that they're not charging hidden fees. Make sure that they're presenting the product honestly. Communicate with the merchant as well. Make sure the merchant understands what's going on. And generally, I don't necessarily think every funder is going to open up a whole compliance department, but you should have trusted counsel who looks over your agreements from time to time, who can answer on specific transactions. I mean, I'm always hearing about, we need this addendum, and, we're going to change the structure, and just the slightest way that could undermine the entire transaction. So you do want someone who's going to look at that. On a bigger picture, I know that, there's a lot of talk about getting out of New York. For a lot of the funders that have been here or based here or have New York as the choice of law in their contracts. I know some of them are going or basing their operations out of places like Utah and Nevada, which don't have, they don't have the usury laws that put these transactions at risk. If they're going to think about that as a way of changing up their business operation, they also need to speak to counsel, make sure they're doing that in the right way. Make sure they're not just, slapping something else on an agreement that's not true, or that doesn't accurately reflect their nexus to that state. Which, one thing we're learning from all this is your agreements really do need to be, dotted with the I's dotted and the T's crossed, because there's challenges that are going to come. And I say not if, but when.
Hmm.
They will come. it just takes one merchant who can't afford or is hostile or gets screwed by some other guy in this industry who now is taking it out on everybody. And I guess the final thing, and I shouldn't have to say this, but I'll say it, is just be honest. Do good business. There's a lot of money out there, and this can be a very rich industry, but people have engaged in some pretty bad conduct, and that's led to a lot of the scrutiny that the industry faces. And just when you think it's over, you hear of some guy filing a confession of judgment against a merchant that didn't even breach 2 days after entering into the agreement. I mean, these are
No.
crazy stories. And if you think that's okay because you have a confession of judgment, it's still theft. And when the regulators come looking at that, that's the way they're going to be thinking about it, not as someone who had a merchant sign an agreement and give up all their rights.
Yeah,
So
100% agreed with that, especially the COJs, and there's so much more. We may have to check back with you and
yeah,
listen, Jacob, I really appreciate it. It was great speaking with you. I think people will gain a lot and hopefully puts them on notice. I mean, there's things happening that they need to stay on top of. So thank you again.
thank you. I appreciate the time and glad to talk about these interesting topics.
Perfect.
Look
All
forward to the
right.
next one.
Yeah, definitely. Thanks a lot. We'll see you soon.
Thanks.